I think if everybody's ready, we'll start this next part of the proceedings, which is concerning the teaching of ethics. It's a great pleasure to welcome to the panel Professor Richard Moorhead from University College London, who's going to be talking about ethical performance in practice. Richard is the Professor of Law and Professional Ethics at UCL Faculty of Laws, and he's led the ethical capacities of new advocates research for the Inns of Court College of Advocacy. He's conducted a range of work on ethics in relation to both lawyers and law students, including, for example, mapping the moral compass studied on in-house lawyers. He regularly hosts events with lawyers at the Centre for Ethics and Law at UCL, which he directed for several years, and he blogs provocatively at Lawyer Watch. And our second speaker is William Ralston from the University of Northumbria at Newcastle, and he's going to also speak on the teaching of ethics. William Ralston, until July 2013, was in full-time practice as a barrister in Liverpool. He joined Northumbria Law School in September 2013. William teaches on the BPTC. He teaches advocacy, opinion writing, conferencing, and professional ethics. He also teaches the law of tort to undergraduates on the M-Law degree. And I think Richard's going to speak first.
Vanessa, thank you very much. Ladies and gentlemen, thank you very much for giving up your evening. It's roasting hot. I'll try to be as quick as I can. I'm asked basically to provide some context to a discussion on ethics and barristers. But what I wanted to begin by saying is that while what I say will be mainly about barristers, what I say I think is probably also likely to be true about solicitors and indeed other lawyers. I've conducted a number of studies on commercial lawyers, in-house lawyers, lawyers and fee arrangements, and indeed law students, and they all tend to point in the same direction, which is to suggest weaknesses in understanding both ethics, professional rules, and indeed the law of lawyering, if we can call it that. The research on the ethical capacities of new advocates, which Vanessa mentioned, is unusual, though, because what it does is it seeks to directly evaluate the knowledge and skills of advocates, and that's not been really much done before. To get it across in a nutshell, our interviewees were subject to essentially six mini vivas on ethics problems, the kinds of problems we thought, and we designed them with the Advocacy Training Council, now called the Inns of Court College of Advocacy, and with expert assessors who were practitioners and judges with experience of training in ethics. We designed the problems to be problems that would occur in practice and were fair tests of the abilities of the advocates to deal with ethics problems on their feet, as it were. They were, we hope, therefore not too difficult or too easy, testing, but fairly so, if we can put it in those terms. The research was funded by the Legal Education Foundation, and it concentrated on barristers within 3 years of taking up tenancy. In fact, we actually surveyed 349 advocates, barristers, solicitors, and some chartered legal executives, and conducted 77 interviews. It's mainly the interviews I'll talk about. And we surveyed them with a sample of 6 ethics problems from commercial, family, civil, and in-house practice. Both the survey and the interviews garnered views on ethical training and, as I say, tried to assess the interviewees on their ethical capacities, their skills and knowledge in dealing with ethical problems. I should also say that in getting people to talk to us in interviews, we're likely to suffer from selection effects. So the kind of people who are willing to talk to researchers are not necessarily typical of all advocates. And we have to guess a bit as to whether they are better or worse than advocates in general. And I'm not going to guess here. You can ask me afterwards what I really think. But I want to put that out there. We cannot say this is the generally true standard of all advocates. The second thing I want to say is the judgments which I rely upon are not my judgments, but the judgments of the expert assessors. So what we essentially did is design a process by which we collated the expert views and analysed those expert views on those interviews with advocates and barristers in particular. I think there are about 66 barristers in that sample of 77. So what did we find? Well, in broad terms, there were 3 groups, okay? There was a group who was stronger, there was a group who was weaker, and there was a group who was weak. And I wouldn't want to put very strong proportions on that, but the middle group is probably the bigger group. But the other two groups are sizable enough to be interested in them. Those performing well demonstrated a strong knowledge of professional principles, one would hope so, and the rules, and confidence in their application of those rules and principles to the problems that we posed them. They could apply the rules and principles to the facts as they were given them. What I should say, though, is such high performance was fairly rare, and even amongst the best interviewees, there were generally some weaknesses on some of the questions, albeit usually fairly minor. So even the very best were not perfect, as one perhaps would imagine or expect. We wouldn't expect them to be perfect. The weaker interviewees, here's where it's, if you like, starts to get interesting, more concerning, didn't spot most of the duties and principles engaged by the problem. So they were generally missing some of the relevant principles and rules. They failed to balance competing duties, so they would concentrate on the duties to the client or the duties to the court, for instance, and they showed a lack of confidence when considering the implications of the problems for case handling. They couldn't think forward and explain how the problem would affect how they would deal with the case. The weaker interviewees tended to demonstrate those problems, but more frequently, tended not to recognise significant ethical dimensions to a problem, showed a stronger tendency to rely on intuitive responses to problems, gut feeling, if you like, treated ethical dilemmas as tactical dilemmas. Well, what we would do here as a matter of tactics is rather than facing up to the ethical problem, and I'm afraid got relevant principles or rules wrong, and significantly so. The poorest, it gets worse, appeared to have a very limited grasp of ethical principles, sometimes saying some fairly alarming things. Okay, so those are the principles in a nutshell, and that's got about half my time expended. So what can we say about training? Well, I'll tell you what the interviewees and the survey respondents said about training. The interviewees didn't think there was anything wrong with their basic knowledge, and we would probably dispute that on the basis of the assessments, but they did see a need to develop confidence in the application of ethical constructs. They did feel the need to practice, if you like. What they said about training was quite interesting. There were concerns about the quality of vocational training, the BPTC, sometimes the NPP, New Practitioners Programme, sometimes about pupillage. But what they tended to say was they thought that the professions needed to concentrate on improving ethics training once practitioners entered practice, so during pupillage and thereafter. And this is the thing that I think is particularly interesting to me, that this improvement needs to be engendered across the life course of advocates' careers. They didn't think that the LLB, the undergraduate degree, should be a focus for ethics education. I'm going to argue with that later, but they didn't think so. Basically, they thought that students didn't have the practical experience to draw on to make the issues intelligible or sort of tractable to them. And the final thing, which I think is also interesting, is that they thought their more senior colleagues, remember we were looking at relatively new advocates, their more senior colleagues needed to be involved in this ethics training. One reason, you're ahead of me, one reason is they thought that would make for better training, engaging senior practitioners with experience, indeed engaging judges. A second is they thought that senior lawyers probably needed some of that training too. And having spoken to a number of senior lawyers in a range of roles, and I'm thinking particularly of the work that I've done with solicitors, I think this is one of the problems facing the professions generally. I've lost track. I go talk to lots of events like this and practitioner conferences, and I've lost track of the number of times a partner, often a compliance partner in a law firm, sort of sidles up to me after a talk and says, Richard, we really need to concentrate on the young because the partners are just not interested. And maybe the same is true, perhaps to a lesser extent, amongst some of the senior bar. We've lost them, Richard, we need to get them young is kind of the refrain. Well, I'm not so sure about that. I think there is a role for senior practitioners to take this a bit more seriously too. If I can start to think about the implications, so I think this is more for Will than me, it's worth remembering the Legal Education and Training Review. They emphasised what they saw as a number of gaps and deficiencies in legal education and training around ethics, but the centrality of ethics and legal values across the regulated workforce. That is actually the most startling, strongest finding for me from the review, the most empirically strong finding from the review. And yet they see education and training in this area as being variable, and encourage regulators to develop what they call a broad approach to this subject rather than a limited focus on rules or principles. Okay, so how to do that in the time available in education? Well, clinics can play a role, case studies perhaps can play a role. I think we need approaches which are more immersive. I think we need to find, for practitioners, not just for students now, I think we need to find safe but challenging environments for reflection on ethical problems. I hate to use the word safe places, but I guess I am talking about safe places where you go and talk about these things, and talk about these things properly, and talk about them not just in a way which says, well, on the one hand this and on the other hand that, but you have a vehicle for facilitating that discussion which genuinely, rigorously probes into the realities of the situation. I think we need to encourage a harder look at facts. One of the interesting things about the interviews was that actually it was often about the interpretation of facts, not the interpretation of rules. Do these facts mean I'm misleading the court or not? Do I mislead the court or not? And finally, if I may just slightly abuse my time, I wanted to say one thing about the undergraduate degree. I personally think it's essential that we start ethics training in the undergraduate degree. I don't think it's right to say that undergrads don't understand legal practice, so they can't understand ethics courses, they don't understand contracts, they don't understand family breakdown, they don't understand family arrangements, they sure as hell don't understand structured debt finance, yet we teach all these kinds of things on undergraduate degrees. We should also think very seriously about making ethics a more significant part of the undergraduate curriculum, and I will leave it there. Thank you very much.
Well, thank you very much for your attendance this evening, and my thanks to Vanessa for her kind invitation to me to speak. I'm still a practitioner. I practice part-time these days, and a practitioner perhaps still finding his way, embedding into academia. But for the last 4 academic years, I've been part of the teaching team on professional ethics at Northumbria. And I would like to share, I think, what some of my perceptions, and I appreciate that these are entirely my personal opinions, my perceptions of some of the shortcomings of the current model of teaching professional ethics, that we can hope to perhaps address some of the issues in the future that Richard raises and his research when we think again about the way in which we teach the subject. I suspect most people here are familiar with the current model, but just a quick run through. We begin with the syllabus guidance document, which is a document taking us through the parts of the Code of Conduct, a very great deal of it, that are examinable, and also sets out the various matters of code guidance that are examinable. Documents that supplement the code, such as complaints handling, guidance on referral and marketing arrangements, confidentiality, and so on. The teaching of the subject, certainly at my institution, engages a mixture of modes. So we have a number of lectures at which we teach the subject at a fairly general level, and then try and descend into perhaps more detail on what students tend to find some of the more thorny areas of the syllabus. Small group sessions where students prepare problem questions in advance. Those are modelled on the sort of short answer questions that they will meet in the exam. And we insert ethical issues into our skills-based classroom exercises, advocacy exercises, conferencing, opinion writing, to enable the students to try and identify ethical problems in a way that isn't signposted in the way that it is in the short answer question examinations and indeed the small group sessions, and to give them the opportunity of thinking through the sorts of issues that they might come across in practice. By far and away, the majority of our teaching takes place through the small group session. Here, students discuss, as I say, the sort of problem questions that they may be likely to meet in the exam, the ethical and practical issues that arise and how they should be dealt with. The assessment itself, again for the uninitiated, has changed this year to 6 short answer questions. So these are questions where students will encounter a hypothetical barrister faced with an ethical problem, and they need to identify the ethical issue with reference to the appropriate parts of the code. They need to identify what the barrister should or shouldn't have done and what they should or should not do next in order to try and resolve the situation. They are therefore designed to test knowledge, understanding and practical application of our professional conduct rules, and those are all noble aims and a great improvement upon the situation that those of us will recall that was on the bar vocational course. However, and again, in only my personal opinion, this current model does have some significant shortcomings which also impact upon the teaching and learning of the subject. And it is my view that whatever we adopt for the future, it's hoped that we will be able to adopt a model which addresses, ameliorates, or hopefully eradicates entirely some of these issues. I'm going to start with one of my particular hobby horses, and again, I accept there is more than one view on this, closed book examination. So that syllabus document I spoke of contains a large amount of information, great swathes of the code, and a number of guidance documents, some of which run to great length. Another of my hobby horses on this particular issue is public access guidance. The document runs into, I think, nearly 20 pages. Students need to know all of that because it's all examinable, yet you will be aware that in order to do public access cases in practice, you actually have to pass a course in which just about everything that's in that guidance will be addressed. Aside from some other problems that I'll come back to that I think are created by having a closed book examination, I simply, I'm afraid, do not see the need for denying students access to codes and guidance in an assessment. If the students do not know the code and guidance relatively closely, even in a closed book examination, they will fail it. But I think we should be encouraging the students actively to get used to the idea of referring to the document when they need to do so in practice. This shouldn't be something that they're just learning to pass the exam and then clutching in their memory, the reaches of their memory in practice when an ethical issue arises. The syllabus, I do think, needs to be considered, and urgently. QASA, or QASA, Quality Assurance Scheme for Advocates, if you prefer the full, is currently examinable. Money laundering is not. They need to know about it according to the syllabus document, but it's not examinable. QASA isn't in. I'm not aware of proposals actually for it to be brought in. Money laundering, however, is something that you can come across very quickly in practice and in very innocuous circumstances. It's important, I think, that we set the students to the task of learning about that in detail for an assessment. The nature of the assessment is the next thing I want to turn to. Those other issues about syllabus and closed book examination are matters that are potentially able to be ironed out really very straightforwardly. But the assessment itself, the nature of the assessment, is something that I do think needs work. First of all, I think there is a lack of clear guidance as to what the students are expected to pick up or to put in the exam in order to pick up marks. I'll give you some examples. Sometimes a question will give a separate mark for each core duty that ought to be identified. On another occasion, possibly in the same paper, students will need to name or identify 2 or 3 core duties all together in order to get 1 mark. And I can't discern a pattern as to when the difference kicks in. Ceasing to act. Some mark schemes in a paper will give a mark for identifying the steps that the advocate needs to take before withdrawing from a case. In another question where withdrawal comes up, no marks for that. And this is why you get students writing screeds and screeds instead of targeted answers, is because they don't know what's expected of them in order to collect the marks. And that bleeds into something else which I then tie on to closed book examination. I'm afraid that what's going on in bar schools today is that the students are so concerned on anxiously concentrating on recollecting the letters of the code and the guidance that they are not concentrating on the spirit of it. What is talked about in the research that Richard conducted is perhaps the value, and I think it is valuable to understand where your own personal values, the advocate needs to understand those, the student does. And that is being crowded out, in my humble opinion, by putting the students through a massive memory test. They are not appreciating their own personal values. We don't have the space and the time, and the students don't have the space on the course to understand the values underpinning the code. And that is something that I think needs urgent work. I don't believe a continuation of the closed book short answer questions that we currently have is the way forward. A conservative possible option is to have an open book exam. But the other thing that's currently clearly missing from ethics, and this is something else Richard says, is the immersive quality. Part of the trick in practice about being ethical and acting ethically is knowing when you've got an ethical problem, being able to spot it and not being blindsided. And that is something that the course is not currently picking up. We need an assessment, I think, that is embedded, or in which ethical problems are embedded, that put the students through the experience that they're likely to get in practice, where hopefully they will not be blindsided by an ethical problem, and where they will be able to pick it up and work their way through it. That would need to be, in my view, another part of the assessment, possibly by Viva or some other way. I'm run right out of time. I've had the red card, so I'm going to stop there.
Thanks very much, especially to Will, for coming into the Lion's Den to give his view. I'm tempted at the end of the discussion to do a vox pop on open book or not and see what people get. BSB is in listening mode. You'll be pleased to hear that all of the members of our curriculum and assessment review group are in fact in the audience, and I'm sure we'll be listening very carefully to what people say. So, who would like to ask our speakers a question? Ladies here is first with her hand up, and then through.
Hi, a question for William. I'm Liz Cunningham from the University of the West of England, and we teach the BPTC there. So I'm very sympathetic to what you've just said. Thank you very much. Where would you see ethics then being taught if the BPTC is being delivered in two parts? Is it knowledge or is it skills?
Well, it's both, it seems to me. Knowing what's in the code is obviously very important if you were to apply it, but it flows and is connected to the skills intrinsically. It flows right through them like a golden thread. So in my view, ethics is both a knowledge and skills-based matter and would have to be dealt with in some detail in both parts if there was to be a two-part course.
Richard, knowledge or skills, ethics? You've written about this before.
Well, yes. I mean, I tend to agree with what Will said. It seems, and to just pick up on the open book point as well, I think I'm very sympathetic to open book examinations in general, but there are some key things that need to be sort of embedded in the psyche, in the practice, if you like. And I imagine they would be best assessed during the skills parts of the course. So I think about it in those terms.
Okay, thank you. Gentleman over here from... Sorry, I momentarily forgotten your name, but I knew you from the Free Representation Unit.
Michael Reid from the
Mike,
Free
that's
Representation Unit. My views on professional ethics and how it's taught are very influenced, of course, by seeing hundreds of free volunteers each year do their first cases and often face their first ethical dilemmas and problems. And a big part of my job is to guide them through it. So I'm very glad that I was not invited to come and be tested on my own professional ethics as a part of Richard's research. But the thing that always occurs to me is that a big part of professional ethics is what the speakers have talked about the knowledge and the ability to apply it. But what makes it particularly difficult in practice is that you need to do so under very stressful and very difficult conditions. And that's what I see many volunteers facing, is the emotional impact of having to withdraw from a client, or the personal dislike and hatred of your unreasonable client, and it's making the right decisions under those pressures, and also from reading Richard's research, under the kind of commercial pressures that people face, where it's easy to say, of course I would drop that client who was acting unethically, even if they represented 60% of my business. It's much harder to do that in practice and not to be misled. And I wonder, do you think there's a scope for where training can help people in dealing with those things?
Go first, Richard.
Yeah, I mean, yes, I do. I was a student at Warwick many years ago, and we did exactly that sort of thing in the clinic. And it was useful to begin to start to think about those kinds of problems. And I think that's the sort of thing that needs repeating certainly through the early years of practice and possibly beyond that, getting used to having those problems, having those discussions, thinking through your responses and being able to say, actually, I might have got that wrong and maybe I'd do it differently a second time, rather than just forgetting about it and moving on and maybe embedding unreflective or perhaps even poor practice. So yeah, I absolutely think that's possible. It won't be perfect, but it's another sign of why more time needs to be spent on this kind of thing. I know it's very difficult to find the time, but that does take time to develop that professional identity, and I'd rather it was done in a reflective way where people are thinking about it and talking to others about it, rather than we do an exam, we move on, we get on with it, unless something goes badly wrong, we may not think about it again. I know it's not always like that, people do talk about these things, but we need to build some more of that into the process.
Will?
Yes, I agree. I think there is a possibility to deal with it in training. And if providers are willing to be innovative, try and work in clinical legal education, for instance, into their programs, then that provides an ideal opportunity. Of course, you're not going to see all sorts of ethical problems necessarily, given your cases, but you might see some like those you've identified, for instance, the client that you simply don't gel with. And that's important as part of the professional identity.
You don't see the clinic as the safe place, do you?
Well, it's safer because you get a chance to think about it. I mean, none of this, if you're dealing with real clients, none of it is safe because you may have taken a decision, there may be no way back. But people will make mistakes, and the only way of dealing with mistakes is not to punish them at the SDT or the tribunal. So you have to have these moments of reflection, I think.
Okay. Further questions? The gentleman here, and then we've got somebody right at the back, and then I think that'll be probably our last two for the ethics segment.
Hello, Joseph Lees. I'm a current bar BPTC student in Manchester. I'd just like to echo what you said about the very esoteric marking scheme for the professional ethics exam as somebody who sat it this year. And I think potentially an open book exam would only, without more clarification of the mark scheme, just make things more difficult, in that you now have a wealth of resources to dive into and scribble as much down as you possibly can, rather than the memory. So I think if we went to an open book model, it would need to be a much more clear and structured marking scheme. It's just a thought. I was very interested in what you said about the immersive nature of ethics, coming from a previous background of medical education where I taught ethics to medical students. A lot of that's done through role play and assessed at an OSCE Viva type setting. Do we see a place where the exam could move to that sort of, in the same way that advocacy is examined in that way, that ethics would be as well?
Okay. Will, you're the practitioner. Would you like to see it done that way?
I'm not overly familiar with the way it's done in the medical world. it might be that Richard has more knowledge in that respect. In relation to the first aspect that you mentioned, certainly my recommendation is not one or the other. I'm hoping for more guidance in relation to what the examiner is looking for in relation to the marks that need to be picked up alongside an open book examination.
Okay, thank you. And final question, the gentleman right at the back. Hannah's got the mic. Thank you.
Hi, William Seagram, Cardiff University. I wanted to ask a question about the assessment of ethics. As you know, as you've described, the current assessment is 6 questions, and they come packaged as an ethics assessment, so the students know that every one of those questions has an ethical dilemma. It almost turns their mind to this being an ethical problem. Do you think it would be better to integrate these ethical problems back into the skills topics that they do, such as conferencing or advocacy, even if that forms one part of a suite of assessments that could include a knowledge assessment and or a Viva assessment, the type of thing that you've discussed? And do you think that that would be a better assessment of their ability to spot ethical issues?
Thanks. Do you want to start, Will? And then perhaps Richard could follow up and think about it in relation to your study sample, whether that would have made any difference to them.
Yeah, for my part, yes. I think tackling the assessment of ethics is quite a difficult issue when you sit down to think about it. It's quite difficult, for instance, in an assessment to replicate the sort of issues that are going to crop up at court. You're not going to be able, if an ethical issue blows up at court, it's very rare, perhaps, that you're able to immediately sit down and resolve it with the client. There will be you'll be going backwards and forwards at times, perhaps between the court and so on and so forth. And replicating that sort of time pressure, speaking to solicitors, and then speaking to the client is quite difficult in an assessment. But moving the assessment of ethics into the skills-based subjects is at the very least getting closer to the way in which people tend to encounter ethical problems in the real world, in that they won't be signposted, there is an ethical problem here, in the way that we currently have with the paper that the students sit, which is the only real formal mode of assessment on the BPTC as it stands.
Richard?
Yeah, I agree more